From the WATE.com Digital Center, answering your legal questions. This is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
Everyone, thank you so much for joining us this afternoon. I'm Lori Tucker along with Greg Isaacs and the newest addition to our team who's actually been with WATE 6 on your side for a number of years, and that is our executive producer, Jeff McClain, who really truly is the brains behind many of our big news stories and our coverage. I know it embarrasses you, but it's the truth. So
he's your boss, so to speak.
Well,
in a way.
Don't give him that. Don't give him that. We're colleagues. Anyway. I think you're the boss of all of us. We're talking about a case that really has transfixed our entire community. It's a heartbreaking case. It's a tragic case. Now the legal proceedings have begun against Kenneth DeHart, accused of killing a sheriff's deputy, injuring another. This happened back earlier this month on a Thursday evening after a traffic stop that just went horribly wrong in all different kinds of ways. So now, yesterday, DeHart was in court. Let's talk about what transpired in court. This was a preliminary hearing. Let's talk about what happens in these hearings. And this case is on its way to a grand jury. So what are we looking at here? You
know, Lori, a preliminary hearing is a hearing in Sessions Court. Tennessee, we have 3 levels when you're charged with a criminal offense. Sessions Court, when the judge is tasked with determining if there's probable cause that the offense charged was committed. Afterward, that goes to the grand jury. Every state except one, that's Connecticut, has a grand jury. 13 jurors meet in secret. Once again, they're not tasked with finding guilt or innocence, just probable cause, and the case comes out in criminal court. So this is the smallest court or lowest level we have. But, you know, Lori, it's really interesting because in Sessions courts, we see reckless driving cases. We see the smallest and most mundane cases.
And now this.
And then you see, and when you have a case that's this serious and this severe, I hate to use the word big, but when you have a case like this, it's a different vibe. You can tell everyone's facial expressions, the witnesses, the prosecutors, the defense. It's just a different air. And this one, not to be overly melodramatic, but you know, the consequences, according to what I'm hearing from my sources, is life and death. I think the death penalty is clearly going to be on the table.
Well, and one thing that came up in this, the defense team asked to have DeHart's charges. The charges as they stand or as they were presented are first-degree murder, attempted first-degree murder. They asked to have those knocked down to second degree on both of those, arguing there was no premeditation. This was a traffic stop. This wasn't planned. But the judge let it go to the jury under first degree. So could you talk to us about, one, how that request was heard, and two, I guess, where does it go from here? Could the charges go down in the future?
You have two things you can do in a preliminary hearing. One, you can attack the charges if there's a basis, or secondly, use it to get discovery. Use it to learn information and evidence from witnesses. This case begins and ends with the body cams, the dash cam, to attack whether this was a premeditated, a knowing, intentional, premeditated killing of another. What does that mean? Was it planned? Now, so when you're the defense, you want planned to mean forever. You want it to be methodical. You want it to take a while. However, under Tennessee law, premeditation can be formed in an instant. And Ryan Desmond, the elected Attorney General, said, anytime you point a gun at somebody, and you're a defendant, you're a citizen accused, you intend to kill somebody. But their focus yesterday was turning it down to second. So you got first degree, planning, premeditation. Second is just a knowing killing of another. But the proof goes down to possibly life without parole, or 51 years for first, to 15 to 25 for second. So that was the focus of the public defender's office during the course of this hearing.
And again, the judge said no, it's going to be a first degree case.
He said no, and you heard no a lot from Judge Brewer during this hearing. Can we have a continuance? No. We need more time to hire a lawyer? No. Ryan Desmond was on his A game, the Attorney General, and in a lot of counties you see the Attorney General, the elected official, stays in his office and administrates from on high. Desmond was there slugging it out in this hearing. And I mean, he opposed everything. He pointed out that DeHart had 12 days to hire a lawyer. That was sufficient time. He pointed out that the public defender's office handled more murder cases than anybody in this area, so they're well equipped to do so. But he really pointed out very emotionally, he was very prepared, very salient, important facts. For example, that DeHart was asked after this suspicion of DUI, that was the probable cause for the stop, to exit that vehicle, Lori, 37 times.
37 times. Wow. And let's talk about the fact that, well, we found out he did indeed have a gun, and he was a convicted felon.
So here's what the dynamics of this. You have an officer encountering somebody that's weaving. You have PC for a stop. Then you run that person's tag. Well, if someone had a conviction like DeHart did in 2004 for a standoff with police officers, that's going to factor in the back of your mind. And then if you're DeHart, you're a convicted felon in possession of a firearm sitting right there beside you, and the last thing you want is someone in blue to roll up and send you away for 5 years off the top.
And you're saying that's probably what was going through his head, having been through the legal system, knowing, oh my gosh.
And that mental state, Greg, correct, if I'm correct, will matter going forward, because that does get to some amount of premeditation.
Correct. You want it to have happened quickly, knowingly, panic, whatever. What the state wants to do is prove that this, was a planned, premeditated act. But the other thing we heard that's going to be interesting as those two defenses are juxtaposed on the side of the courtroom, when DeHart refused to exit the vehicle, Eggers testified that he was acting anxious and erratic. McCowan rolls up and deploys a taser. So once the taser, after it's deployed, one of the prongs inadvertently hit Eggers. So he's got to deploy the taser, turn down the juice, at which time the dynamic changed, and it changed quickly. That's when apparently DeHart grabbed the gun, fired the shots at McCowan and at Eggers. So, that seems to me like things happened very quick after there was an issue with the taser.
You and I were talking about that earlier today.
Oh, yeah,
it's like it turned so
it went
fast.
From
it went
saying,
from, hey,
please,
buddy.
please, to bang.
Yeah.
Something I wanted to see, Greg, if you could get into is about, I don't think there's any real question that the man seen behind the wheel on that body cam video is Kenneth DeHart. So that video, very clearly, as you said, that's the key. It shows what's happening here. So this would have to be an affirmative defense. It's not a question of what was done. It was how it was done, why it was done. So what does that set up for a potential defense going forward, or sentencing?
Well, what you're trying to do is negate an essential element of the crime. You want to knock out premeditation, make it a second-degree case, make it less likely for the death penalty. But here's something that you struggle with in these big cases with bad facts. When you have a video, this case begins and ends with what is captured on the dash cam footage. It was played during the course of the preliminary hearing. If you're the defense, one thing you always want to consider, am I gaining anything by having more inflammatory, negative publicity for my client who hadn't had time to get a lawyer? I know what the proof's going to be. I know what the evidence is going to be. No surprises. So it's a case that rarely you want to waive a preliminary hearing, but based on this frenzy of media coverage, this case didn't get better; it got worse.
Yeah. There's one thing that we want to remind everybody of, and we're looking at her right there, and that is Deputy Shelby Eggers, who you said that it was electric in that courtroom.
The look that
she
gives,
came in
when she sits down to that witness stand.
She is so tough. But when we look at that dash cam video, and we had former Sheriff Tim Hutchison walk us through it, saying she did it right. She did it right, and it started off, hey, buddy, how you doing? What's happening? Very calm. Hey, you stopped in the middle of the road. I need you to move over. Still didn't move over. Sir, I kind of need you to move to the driveway. It was very, and then all of a sudden, like you said, it turned on a dime. But in court, if we can listen to her and this testimony from her that was so powerful. Let's listen to that for a second.
I fell to the ground immediately, and everything kind of moved slow motion. I couldn't get myself up, and I thought, I took a breath, and I accepted death because I thought he was going to fire at me again. He had an advantage over me. He could have shot me in the back of the head. I thought he was going to kill me.
So there you hear from a 22-year-old deputy who said, I accepted death. How powerful was that?
It's powerful. I mean, it does nothing but throw fuel on the fire of an already volatile case. And again, the end game is, when you have a case that is going to be a capital case, death is different. And, in this case, we touched on it. There are 3 aggravating circumstances that are going to come into play. It's under Tennessee law, when you get to the sentencing phase, life or death, the states must have proven aggravating factors beyond a reasonable doubt, and those must outweigh any mitigating factors proven by the defense. In this one, prior act of violence in 2004, standoff with the police, eliminating or impeding a witness, here trying to kill McCowan as he drives away, spewing expletives. And then third, killing somebody that's a member of law enforcement. So you have 3 solid aggravating factors that you're going to have to address to save this man's life if you're the defense. So, that's something in a case like this, you don't play the short game, you play the long game. And, I don't know what was gained by putting Edgars and the TBI agent through the ringer in the prelim.
Interesting. This will be tried swiftly, yes? Is that what
I
you
was
feel will
wondering-
happen?
Well, I was wondering if it was if maybe it would be moved out of this jurisdiction, given the fact that this is, any potential juror out there may have seen that this body cam, they may have seen the funeral services, the procession.
Well, let's talk about how that works. The defense is going to file at some stage, once it gets to criminal court, a court of record, a motion for change of venue. And people always think, well, that means the case, kind of like the circus, goes somewhere else, etc. That's not how it works in the 21st century. What happens is we go somewhere, get the jury, and bring them back. Right. So somewhere in Tennessee, there's a county, and some unwitting people are going to be summoned to a jury panel, and then they're going to be asked a few questions, sequestered, and brought to Blount County. Really, it's remarkable. And when you try those cases, when we tried the Husky case, we had jurors from Davidson, we had them from Rutherford County, Kenny Bartley and Campbell County. It was a Nashville jury. It's kind of strange because you look out and see people that you can tell are different when you're doing the voir dire. The responses are a little different. So I'm fairly confident you will not see, well, back to your point, Jeff, this case, they're going to keep the pedal to the metal. And this is just a taste of that. So it's going to go at warp speed. People talk about the accused has a right to a speedy trial. So does the state. And they're going to get it. They're going to push it. But on the other hand, I think once that day comes, you're going to see 12 jurors that are not residents of Blount County.
Will it make a difference?
This made national news.
It very well may. But you know what both sides want at the end of the day? You want a jury that can be fair and impartial. And even if you get someone that the publicity's not permeated the veneer, they've not seen anything, they know it's big and they know it's bad, or they wouldn't be put in a bus brought to Blount County. So it's just the specter of having a jury come to another place, even if they don't tell you about the publicity, you know that this is not a typical case.
No, it is certainly not. We're going to leave it there, Greg. Let's talk more about this at 5:30.
Let's do.
Jeff, as always, thank you.
Thank you, Jeff.
Thanks for being with us.